Greetings and welcome. My name is Don Alexander. I'm President and Managing Director of GeneCoda Executive and Professional Search. We connect outstanding firms in the life sciences sector with executives who help bring game-changing products to the market. I'm pleased to be joined here today with Barry Buzogany, an advisory board member of our firm. Barry is a professional board director and former C-suite executive for both public and private pharmaceutical, life sciences, med tech, and contract research organizations. Barry is currently serving as director on select advisory and statutory boards to share his wealth of leadership experiences, extensive domain knowledge, and lessons learned as an accomplished operations and legal executive and entrepreneur. Welcome, Barry.
Thank you. It's great to be here.
Thanks, Barry. In this video series, Barry and I will be discussing the functions of corporate and advisory boards, including the legal and practical differences and pros and cons of each, why consider a board of directors or advisory board, and when is the right time, how to form a board and criteria for selecting board members, and how to compensate board members of the board of directors or advisory board. So in this video, we'll be discussing some of the legal and practical differences between corporate and advisory boards. Barry, can you give us a high-level overview?
Certainly. In fact, high level is a good usage because much of what I'm going to say and the points I will make could be followed by, well, it kind of depends, or it can vary for sure. So this is definitely a high level. It depends in large part because it depends on the type of organization we're talking about. Is it a public company? Is it a private company? Is it startup, or is it, a mature company, post money? So there are those distinctions, but in terms of at the high level, there's major differences between the advisory board and a corporate board, and I'm going to refer to either corporate board or boards of incorporated companies. I'm not going to worry about whether it's an LLC or an S Corp and so forth, because those are tax ramifications and not relevant to what I'm talking about. So when I say incorporated company, it could be any kind. The big difference at the top is that an incorporated company is a statutory company. That is to say that if you form a company and incorporate it by state law, you have to do so in a required way, which is not true of an advisory board at all. There's no state law or other requirement that an advisory board be formed. That's purely discretionary. So that's really kind of the major difference between the two at the highest level. And I would say that as far as how they're governed, the state requirements when you incorporate will set forth that you have to have articles of incorporation, and then you come up with your bylaws, and those will speak to having a board, how many members, how often will it meet. All those that's why I say highly structured. That's because it's set forth in your bylaws, which are required by law. Now, I would say that all the states in the union allow for a founder of a company, for example, or a CEO to be the board initially. But what we're talking about today is when there's a fully formed board. So again, an advisory board does not have that kind of requirement. It's purely discretionary on the part of the CEO to form such an advisory board. In terms of who and how many and all those kinds of things are up to the discretion of the board itself. So it's a much less formal, less structured organization. In terms of the governance, on a board, an incorporated company's board would report to the shareholders and are accountable to the shareholders. Whereas the advisory board, again, is accountable to the CEO that formed it. So again, a major difference, and we'll talk about fiduciary duty in a second, but that is an important point as well.
That's great, Barry. That was really helpful. Question for you: should the board be given access to the internal operations and employees of the company?
Well, that's a good question. In fact, that too can vary depending on the opinion of the chairman of the board in an incorporated company and the CEO in terms of how they want to play that, so to speak. Now, my own opinion is the answer should be yes. I think even with respect to a fiduciary board or a statutory board, that the answer should be yes, because it's important for the board, in order to have full understanding and appreciation of the company's business model and its operations, to have access to the senior management team. So, for example, in a given board meeting, the CEO might want the CFO to give the report on finances rather than CEO giving it to the board. The same with the others on the senior management team. The chief scientific officer might want to give that report and that update on clinical trials, for example, rather than having the CEO do it. It gives the board members access to an appreciation of, at the senior level, what's going on in the company. And the reverse is true. You're giving access of the senior managers to the board as well. So I think that's a good idea. And on an advisory board, I think it's even a better idea, because advisors, again, they're loosely organized, and they are at the disposal of and really on call to the CEO and the senior team. So by the nature of their very role is that they should be able to interact with the senior team and the staff as the CEO may wish it to be. Now, remember that a given company can have both, of course, a statutory board and an advisory board. So if a company that has both wants to set up an advisory board, that would come through the authority given to it to do so by the statutory board. But short answer to your question is yes, I think that the access is important.
Fantastic.
So I think we should touch on the legal liability next, because I made a reference to the fiduciary duty. And again, the state law sets forth that board members in an incorporated company have a fiduciary duty to that company. What does that mean? Well, that means there's a legal liability on the part of each of the board members who serve. Legal liability being defined over the many decades of case law as a fiduciary duty, meaning that there's a duty of care and a duty of loyalty that the board has to the shareholders of that company primarily. They actually kind of report to the shareholders. And when I say duty of care, that really means that when they make decisions that are binding on the company, they should be informed decisions. And so they should be very well aware and as to what the operations of the company are, because they have to approve the annual operating plan, for example. So it's a duty of care that says you should be informed and make informed decisions on behalf of the company and its shareholders. The duty of loyalty really speaks to the fact that an individual shouldn't be making some improper benefit from his place on that board. That the loyalty is, again, to the shareholders and to the company. Now, as far as the advisory board, there's no legal liability because they have no vote. They do not make decisions on behalf of the company. So the only thing I would mention is that there are two agreements, at least, that the CEO should enter into with its advisors, and that is one being a CDA, a non-confidentiality agreement, the other perhaps a non-compete agreement, and both of those could be folded into an advisory board agreement, which I also recommend. And the advantage of that is because the advisor can, in each advisor's case, he can set forth, the CEO can set forth what the scope of his responsibilities are. So it's clear what's expected of that advisor and vice versa. So those are the three documents that would give a contractual duty then of the advisor to the company, but not a fiduciary duty. I think then moving from that to oh, by the way, I should say too that one of the reasons you find that board members on a statutory board company insist on a D&O coverage, directors and officers liability, is because in fact they do have the potential of personal liability to the company and to third parties, and so that's where the D&O insurance always comes into play. Again, not necessary in the case of a advisory board because they don't have a vote, they don't have the ability to make decisions, and so they don't have that same risk, if you will, or exposure. I could speak as well, Don, to the duties then of the two different kinds of boards and try to make some distinctions there. The board of directors in an incorporated company really has accountability and responsibility for overall oversight of the company, which means that they're going to want to approve an annual operating plan of the company. They're going to, which would include approving financials and budgets, because again, they're responsible at an oversight level and a higher level for that. So their advice really comes from at a strategic level, management level issues that they have to deal with. For example, if the CEO wanted to form a partnership or raise a round of financing, then that's the kind of sort of major event that a board has to weigh in on and either approve or disapprove and give guidance to the company in implementing it. On the other side of the ledger for an advisory board, again, what you're doing there in forming that board is bringing on at your disposal, kind of on an as-needed basis, subject matter experts who can fill maybe a void or even just reinforce expertise that you have in your senior management team or among your staff. So for example, the chief scientific officer of a life sciences company may well want to have a scientific advisory board at his disposal. It may be clinical trial experts, it may be medical doctors, it could be, anyone on the science side, the financial folks the same. So it can be any area of expertise that the company feels a need for, but can access on an informal basis, again, and those folks have no decision-making authority, but are there to lend a hand and have an extra level of expertise for the management team of the company. So a big difference, again, in terms of the duties. The advisory board is at your disposal and may not even meet. That's the other thing. They don't have an obligation to meet at all if the CEO chooses to use them in that way. They can just be on the other end of the phone, or you can have lunch with them and pick their brains as necessary, or have them meet with one of your teams in the company. So that's a difference, whereas a corporate board must, by its bylaws, have meetings at least quarterly, and they must be meeting in person or these days online. They can meet virtually, but to make decisions, they have to have a quorum, and they have to have a vote, and then that decision becomes binding.
It does sound like the advisory board also provides some level of strategic guidance when we talk about things like scientific advisory boards as well. I just wanted to make sure I understood that part of it as well.
No, I think that's a fair point, and I should have pointed that out, that indeed, while they are not accountable for the overall strategy of the company, such as a board of directors is, the board, on the other hand, is oftentimes, again, at the higher level, setting forth a strategy, but there may be strategy options that the management team has the opportunity to make decisions on, and they may want to call in advisors. Again, a scientific advisory board is a good example. If you're in clinical trials or developing a drug or a device, the board may set forth what the operational strategy is for that given year, but you as the CEO definitely would want to call in some experts if you need them, and so you can argue easily that, yeah, those folks are actually helping you as the CEO devise the strategy that has at a higher level been approved by the board.
Excellent, thank you.
Sure. So one other point we could make is about what's the difference between these two kinds of boards relative to the time spent and the meetings, and I've already touched on that in the sense that the statutory board folks do have an obligation to be well informed and be very close to the operations of the company, given their fiduciary duties. Whereas the advisory board, again, they're coming in on typically a one-off situation, or they come in and meet with some of the staff. Again, so that's more informal, and they don't have a requirement to meet in person at all, as a group, I should say. And that's up to the CEO. Maybe once a year you want to have a dinner to bring them all in and thank them for their service. But that's more of a casual one-off kind of basis. So there's no requirement for actually having meetings, which again is not the case with the statutory board. The meetings are set forth in the bylaws that you will have probably typically at least quarterly meetings, if not more. So that's kind of how it plays out as far as a more formal structure of an incorporated company's board versus advisory boards.
That's great, Barry. Thanks so much for your guidance. Our next video in this series will cover why to consider a board of directors or advisory board and when is the right time to do so.